for today. Okay, go ahead.
Arthur Shopper.
English lady?
Let me know when you're ready.
Okay, go ahead.
Arthur Shopper. S as in Sam, C as in cat, H as in hat, A as in apple, P as in people, E as in elephant, R as in rabbit.
Okay, and where are you from?
I am from Torrance, California.
If you could just say, I'm Arthur Shopper from Torrance, California.
Sure. My name is Arthur Shopper, and I am from Torrance, California.
And what brings you to Glendora here today?
I'm here to support every municipality that takes a stance against Senate Bill 54, the sanctuary state law. I want my city to take a formal stance against the law, file an amicus brief, issue a stay of compliance. I'd love to see Torrance do the same thing that Los Alamitos did, which was to opt out entirely by passing their own ordinance. Yes. And I'm here everywhere I can to make that case, to inform other people, to challenge the misunderstandings of some people who see this as like a form of bigotry or racism, but it's not about race, it's about the rule of law.
And are you affiliated with any of these other, it seems like these people support your cause or your side of it?
I'm part of the Remembrance Project, We the People Rising, yes.
Welcome.
And LA County for Trump.
Thank you for being here, and the day has come. The council is all here. Thank you for being here, and as the mayor, I want to welcome you. This is a chance for a conversation to be had about something that everybody here knows about. And the council during the summer talked about this for a couple months and looked at everything and decided, okay, this is something that we should have a town hall on. So this is why we are here. The purpose of this town hall is to enlighten, to allow us to learn, to allow us to maybe hear some things that we didn't know. And hopefully we will all go out with a better assessment of what SB 54 is. And so that's what we are attempting to do. So I am pleased that we have a panel that is well versed in this. And as you can see up there, that's who they are. But Anita Lee is right here to my left. She's from the state, and she's a principal fiscal and policy, wonk. She's an analyst. And so she knows a lot about this, bill. And we are thankful that you are, here. And so thank you for sharing with us. And our city attorney, Bill, is right here. And Bill, thank you for taking your time to be here. And from the sheriffs, Mr. Moore, John. And thank you for taking your time to be here. And we appreciate that. Because it's part of the plan here to let you know about what this bill is and how it affects us. Because it affects each and every one of us. And so we have the state, the attorney, sheriff, and they all have a real keen sense of how this bill affects us.
Can we begin with
that is why we're
Pledge of Allegiance?
that we're here. So with that, I'm going to turn it over to our city manager.
Can we begin with the Pledge of Allegiance?
Yes. Pledge of Allegiance.
If you want to stand, let's go ahead.
Let's do it. Yeah.
You heard me the first time.
The flag is right there, and for those who can stand, please stand. And ready, begin.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. There we go.
And with that, I want to introduce our city manager.
This is what it comes to.
Thank you, Mayor. Good evening, everyone, and welcome. My name is Adam Raymond. I'm the city manager for this glorious city. Tonight is not a city council meeting. It is a discussion on SB 54 with a panel. At the conclusion of the panelists, we will be able to ask questions. I will MC those questions and walk around the room, and you can ask your questions in person. We ask that you state your name, and so you can ask the question so they can respond to you accordingly. In order to facilitate this conversation, there are some ground rules that are both behind you and up to your right. Please do not yell out for the crowd. There is no hate speech, no profanity, and no threats. You will be warned and then you will be asked to leave. Questions at the end, sir. And with that, we will turn it over to Ms. Anita Lee. Thank you very much.
Great. Good evening, everyone. My name is Anita Lee. I am a Principal and Fiscal Policy Analyst with the Legislative Analyst Office, or the LAO. For those of you who are not familiar with the LAO has been providing non-partisan fiscal and policy advice to the legislature for over 75 years. We're best known for our analyses related to the budget process that are proposed by the governor, legislators, and stakeholders. But we also provide assessments and recommendations to the legislature on implementing policies in the most cost-efficient and effective way possible. One of the other things that we do is that when citizens want to file a public initiative, we're actually responsible for preparing an estimate of the fiscal impact on state and local governments before it can go out for signatures. And if it qualifies, we prepare the analyses that will appear in your voter information guide. So I just want to reiterate again, our office is nonpartisan. That means that we do not take stances on bills, policy bills generally. That includes SB 54. So I was asked to come today to just set the stage and provide background so that everyone is sort of on the same page. And so my comments are really going to start with the federal-state relationship related to immigration enforcement. And then I'm going to talk about a couple of the bills that were put into place before SB 54. And then finally talk about SB 54 and kind of the nuances of what's included in it. So first, if we turn our attention to kind of federal and state relationship related to immigration enforcement, federal law generally governs immigration. That includes specifying who's allowed, individuals from other countries, who's allowed to enter the United States, the tracking of individuals, their entry and exit. It also specifies the rules for which the process that has to be gone through if they want to legally remain in the United States. And then it authorizes arrest and detention for those who are unlawfully present. The federal government is generally responsible for enforcing immigration laws. They do have a variety of tools and programs that are in place. The most common one that we all know about, and I think we see signs on, are ICE, Immigration and Customs Enforcement. So one of the major programs that is used for this purpose is a program called Secure Communities. And so I thought I'd kick off just explaining what is this, because I don't think a lot of people know. So when an individual is arrested, a copy of their fingerprint is taken. And that fingerprint is submitted by state or local law enforcement to California DOJ to verify the identity of the individual and also to obtain information on their criminal history. At the same time, while the state's searching its records, the fingerprints are also forwarded to the FBI to obtain information on federal and out-of-state arrest, conviction, and warrant information. Under the Secure Communities program, federal law actually requires that the FBI automatically send copies of the fingerprints to the Department of Homeland Security for them to screen against immigration and other databases. The output of all of those searches is sent back to the requesting agency, but to the extent that the check notes that the individual is unlawfully present in the United States and is removable, ICE will then determine what enforcement actions, if any, it wants to take. So then, from that purpose, ICE has a number of different tools, and I'm going to cover them because it's going to be important when we talk about SB 54. One of the primary tools that is discussed is the detainer or hold request. And that is a request by the federal government for state and local law enforcement to maintain custody of an individual for up to 48 hours, excluding weekends and holidays, beyond the date which that individual would have otherwise been released. And that allows ICE to determine whether or not they want to assume custody of that individual. These requests are prepared administratively by ICE, and so compliance is usually at the discretion of state and local law enforcement. I would note, though, that the federal courts can also issue arrest warrants or search and seizure warrants, and compliance with those are generally required. They're not discretionary. On top of that, federal immigration authorities have the ability to ask state and local law enforcement to notify them in advance of an individual's release date, or to transfer an individual into federal custody. Compliance with those similarly are subject to the discretion of state and local law enforcement. The final kind of major tool where states can be involved is that beginning in about 1996, the federal law actually authorized ICE to delegate some enforcement authority to state and local law enforcement through formal agreements. These agreements are also commonly referred to as 287G agreements after the statute that authorizes them in federal law. Those federal agreements generally specify what authorities are being transferred over, which personnel are eligible, training and supervision requirements, and funding and data responsibilities. So that kind of sets the picture at a high level. So then if we turn our attention to kind of state law, the state has enacted a number of different laws that touch on immigration, and they cover a whole variety of policy areas ranging from criminal justice issues to education, to health, to labor. So I'm really going to focus on kind of two bills that kind of first went into effect and that are impacted by SB 54, and then talk about SB 54. So the first one is the Trust Act, or 84, which was effective in January of 2014. Under that law, it limited the discretion of local law enforcement officers to comply with detainer requests. And specifically, they could comply with detainer requests if it was consistent with existing federal, state, or local laws, and if certain conditions were met, most notably that the individual in question had been charged or convicted of certain misdemeanor or felony offenses. For example, murder, assault, gang-related offenses. But there were also some other things on the list like felony DUI or unlawful possession of firearms. That bill or that statute did not impact any other type of coordination or interaction between state and local law enforcement and the federal government. So for example, it didn't touch on notification on release dates. The second bill that kind of is important in this discussion is the Truth Act, which was AB 2792, and that was effective in January of 2017. Under that one, local law enforcement was required to provide individuals with certain information in advance of an ICE interview. And specifically, they were required to provide a written consent form that had to be available in different languages, and that form had to inform the individual of what this interview process was, that the interview was voluntary, and that they could decline the interview, or they could specify that they were only comfortable doing the interview in the presence of their attorney. Additionally, that act required that state and local law enforcement, when they received either a detainer, notification, or transfer request, that they would have to provide a copy to the individual and also tell them whether or not they intended to comply with it. To the extent that they were going to comply with a notification request, local law enforcement was also required to provide the same information to the individual that they were going to provide to the federal government. To the extent that there was cooperation and ICE was allowed to access to interview individuals, beginning January of 2018, local governments whose agencies authorized that were required to conduct at least one open public community forum where the policy of ICE access was to be discussed and public comment was to be allowed. So finally, that leads us to SB 54. It's also known as the Values Act. It became effective this year. The major thing about it is it covers both state and local law enforcement, but it generally excludes the Department of Corrections and Rehabilitation, except in one aspect, which I'll get to shortly. So first, how does SB 54 interact with kind of the two bills that I just talked about, right? So first, in relation to the Trust Act, or AB4, which I mentioned before, kind of limited compliance with detainer requests. Under the Values Act, compliance with detainer requests were generally not permitted. Instead, those restrictions on compliance were put on notification and transfer requests. In relation to the Truth Act, the requirements for notification that local law enforcement were required to follow. Under SB 54, the Department of Corrections and Rehabilitation would now be required to follow some similar requirements. So on top of all of this, SB 54 kind of included a number of other components. It generally prohibited the use of state or local resources, includes both money and people, for the investigation, interrogation, detention, or arrest of individuals for immigration-related purposes. This included inquiring about an individual's immigration status. We talked about compliance with the detainer requests, complying with notification or transfer requests if they didn't comply with the Trust Act that we talked about, providing personal information that was not already publicly available or not publicly available through practice or ordered by judicial order, intentionally participating in arrests that were based solely on civil immigration warrants, and finally assisting with immigration enforcement activities, which included those 287G delegation of authority agreements. The Values Act, or SB 54, did authorize certain activities. So for example, state and local law enforcement are still authorized to participate in joint task forces to the extent that the primary purpose of the task force is not immigration enforcement. It also still permits ICE access for interviews, and it also does not, it specifically still authorizes communication between law enforcement agencies with other governmental agencies, which includes the federal government, related to citizen and immigration status. Under federal law, law enforcement officers are allowed to send, receive, request, maintain information on citizenship and immigration status. For those agencies that did choose to comply, the SB 54 did impose some data requirements. For those that chose to comply with transfer requests, they would be required to report annually on the number of transfers that occurred and the specific offense that authorized that transfer to occur. For those that chose to participate in task forces, they need to report annually on the makeup of the task force, the number of arrests that the task force kind of effectuates, and the number of arrests that were specifically related to civil immigration enforcement, essentially. And finally, the California Attorney General was required by the bill to provide guidance in a number of different areas. It was required to provide guidance and audit criteria to state and local law enforcement for how to maintain their database and ensure that their databases, which includes information on immigration, complied with state law. It also required the Attorney General's office to promulgate guidance and model policies for certain types of businesses, such as or entities, so because it included the courts, healthcare facilities, shelters, and labor agencies, about how they could limit assistance related to immigration enforcement. And the Attorney General's office actually just promulgated those regulations a couple weeks ago, and so those entities are currently in the process of reviewing them and deciding how they're going to move forward from there. So with that, I'll conclude my comments. Happy to provide any clarification or if you have any questions down the line, but I'm going to turn it over to